very good morning to all of you. It's my pleasure to give you a very warm welcome to this sitting together with my colleagues, Ambassador Celorio and Dr. González Ecosio. This is a hearing that has to do with the case concerning the Helian High Synod. Sorry for my pronunciation, but it comes close. And it has been submitted before the court by the state of Adagua as applicant who instituted proceedings against the Republic of Rasasa, which is the respondent, with regard to a dispute where the respondent would be allegedly in breach of international law. May I add, by the way, that I want to express my appreciation for all the facilities and the arrangements undertaken by the Ministry of Foreign Relations of Mexico to provide the seat of these hearings. I'm sure that my colleagues in this court joins me in thanking very much indeed the Ministry of Foreign Affairs for the help that has been provided for these Jessup competitions. Now I will give the floor to counsel for the applicant.
Mr. President, Your Excellencies, may it please this honorable court. My name is Ana Paula Gutierrez, and along with my co-agent, Mr. Andres Rondas, and Mauricio Arciniega of Counsel, we appear on behalf of the applicant, the state of Ottawa. I will speak first for 22 minutes. My co-agent will speak next for 21 minutes, and we have requested to reserve 2 minutes for rebuttal. Your Excellencies, before I begin, would you like a brief restatement of the case file?
I think that would be useful, yes.
Thank you, Mr. President. The dispute concerns 4 issues. The first is whether Ottawa should be considered as a party to the 1929 Treaty of Bottega, since the instrument was originally ratified by the Ottawa-Setunia Union, Ottawa's predecessor state. The second claim concerns the Wall, a fully autonomous weapon system that will instantly respond to threats through artificial intelligence. It was developed by the parties under the leadership of RRC, a Rasasan corporation, as a potential response to crime waves resulting from a hurricane that impacted the whole region. Rasasa later deployed the Wall on the border between Rasasa and Ottawa. The third issue concerns helium, a flavoring spice endemic to the Crucinian region, and Rasasa's imposition of tariffs on helium products. The claims discuss whether such imposition of tariffs is covered by the CHC Treaty, an instrument ratified by all 6 Crucinian states. Finally, Ottawa's arrest of Rasasa's Ministers of Foreign Affairs and former CEO of RRC, Ms. Darian Gray. An arrest warrant was issued by the International Criminal Court due to her alleged involvement in aiding paramilitary forces in conflict zones on a 3rd state. Your Excellencies, this case is about accountability. Throughout the submissions that will be made here by the parties today, we ask the court to keep in mind that duty lies at the other side of rights, and thus every right implies responsibility. On that note, I have 2 submissions to make before this court today. First, that the court has jurisdiction over Ottawa's claims, and second, that the deployment of the Wall along the border between the parties is inconsistent with international law. Turning then to my first submission, Your Excellencies, the court has jurisdiction because Ottawa must be considered as a party to the 1929 Treaty of Bottega. Now, for this argument, we are relying on Article 34 of the Vienna Convention on Succession of States with respective treaties, which sets out that in cases of state dissolution, treaties in force at the time of succession continue in force ipso facto to each successor state so formed. Now, under the conditions for this rule to be applicable, Your Excellencies, the International Law Commission established that the succession of states must be in line with the object and purpose of the treaty, and second, that it cannot radically alter the conditions for the treaty's operations. And in our submission, both of these conditions have been met. Turning then to the question of whether the considering Ottawa as a party to this treaty is in line with its object and purpose, we do submit that we could find in the preamble of the Treaty of Bottega that the parties agreed to renounce all recourse to armed force as an instrument of policy among Crucinian nations. They also recognized the need to protect the Indi-Machilian fields, and they desire to renounce or to save succeeding generations of Crucinians from the scourge of war. And it is in light of the preamble that Article 6 of the Treaty of Bottega must be read. Now, Article 6 contains a compromissory jurisdiction clause whereby the high contracting parties to the treaty decided to refer all disputes arising between the parties to the jurisdiction of the court. And we do submit that Ottawa, as a Crucinian nation, has recourse or must have recourse to this court on the basis of Article 6. And turning then to our second submission, Your Excellency, considering Ottawa as a party to this treaty does not radically alter the conditions for its operations. And that is because we put forward that the consent required to establish the jurisdiction of the court has already been submitted by the respondent by way of Article 6. Now, considering Ottawa as a party to this treaty imposes no additional obligations on Rasasa. Rather, it merely serves as a reflection of Rasasa's commitment to save succeeding generations of Crucinians and renouncing recourse to armed force as an instrument of policy among these Crucinian nations.
So, sorry, I would wish just to ask you something which has to do with the statement of agreed facts. Why is it, I mean, I realize that you are somehow going into the discussion of these matters, but why is it that the parties decided to submit this statement of agreed facts? Because let me tell you that I find it a bit surprising, to say the truth. It's a very unusual procedure in the terms of the court. It's not the tradition that the parties will submit a statement of this sort before the court, because wouldn't that go against your better interests? By that I mean, aren't you somehow forfeiting flexibility, capacity to argue, because you are somehow enclosed in the facts that you have already provided to the court? Was it a political decision, or does it have any political implications that we may wish to know? Or was it simply the possibility that it would become easier to come before the International Court of Justice in order to be able to have access to the jurisdiction of the court?
Mr. President, the answer to your question may be found, forgive me, Mr. President, the answer to your question may be found in paragraph 59 of the Statement of Agreed Facts, whereby the court entered an order recommending the parties to submit or draft a statement of agreed facts. However, this was without prejudice to any argument that they might seek to make during the proceedings. And it is under this contention that we submit that the parties are not constricted or limited by what is stated in the Statement of Agreed Facts. Rather, they might make additional or subsequent arguments in the event of, for the purposes of oral and written submissions, Mr. President.
Right, but let's accept that it was only a recommendation, and it was up to you. You had full flexibility to accept or not accept that recommendation. You were not obliged to follow the recommendation of the court. There must be some other motive for that.
Certainly, Mr. President. Now, it is in the interest of the Ottawan state that the doors to this International Court of Justice are open to us in order to peacefully solve our disputes with Rosasa. And that is because first, we did consider ourselves as bound by the Treaty of Bottega as a successor state, and thus under the obligation to submit any disputes specifically to this court. And second, because in the interest of continuing the relationship between Ottawa and Rosasa, given their the history of their long friendship and their complex and intricate interrelations regarding the Christine and Helian community or their Helian industries, we did consider that it was in the best interest of both parties to have this court hear the submissions made by the parties today. So that is our political reasons for bringing the dispute before the court. So turning then to our submission or alternative submission, that even if this court were not to consider that Ottawa is a party to the Treaty of Bottega, we would submit that this is not fatal for our argument regarding the inconsistency with international law of Rosasa's deployment of the wall. And that is because if we look to the prayer for relief, we see that Rosasa asked the court to adjudge and declare that the development and deployment of the wall was lawful. Now, as this court held in its decision concerning minorities in Upper Silesia, an express declaration, or rather an express request by the respondent to have the court declare or adjudge on a specific claim without making an objection to jurisdiction is sufficient in order to establish consent for this court to hear the claim. If your excellencies have no further questions on this specific matter, I would then turn to our second submission concerning the deployment of the wall. Now, in this second issue, your excellencies, our submission is that Rosasa's deployment of the wall is inconsistent with international law because it constitutes an unlawful use of force against the Ottawan territory. Now, this prohibition is established in Article 2, Paragraph 4 of the United Nations Charter, which establishes that states must refrain from using armed force against the territorial integrity or political independence of other states or in any other manner that is inconsistent with the United Nations Charter. Now, we do submit that this deployment constitutes a use of force, and an unlawful one at that, because it threatens or interferes with the sovereignty of the Ottawan state to fulfill its obligations, for example, under the International Covenant on Civil and Political Rights. Is there a concern, Your Excellency?
Please, by all means.
Would you like to speak first? Ms. Gutierrez, has there been any shots fired
There have,
since the installation of the wall?
There have, Your Excellency. We do know from the corrections and clarifications to the Statement of Agreed Facts that in the 2 years that the wall has been deployed, the wall has issued 5 warning shots and 100 instances of verbal warnings.
Thank you. And if I query whether it's really a threat or actually a response to a threat, what would you tell me to convince me that it's actually a threat and not a legitimate response to a threat that the government that is installing the wall is suffering?
Is Your Excellency referring to why this is an unlawful threat of force?
Yes, that is correct.
So under our submission, Your Excellencies, this is no longer a threat of force, but an actual use of force. And that is because the use of force, as understood by the Charter, is that of armed force. And there is, when a weapon is activated, that does constitute a use of that force. Now, there are some weapons in which the deployment and the activation might be either under 1 second or it may take 30 years. We should take, for example, when we deploy a gun, we fire the trigger and then the weapon is activated by firing the bullet. Or however, we could, in the example of mines, we could activate the mine, but it might take 30 years for someone to step on it and it actually be activated. Now, on our contention, the deployment of the wall is now an actual use of force because it is already activated in order to respond to threats by, in some instances, using lethal force. So the question of whether or not to deploy force is no longer in the hands of the Rosasan government, Your Excellency. It is already in the figurative hands of an autonomous weapon system that can make decisions without any need for human intervention. So it is our position that it is no longer a threat, but an actual use of force. Does that satisfy your question?
It does, thank you very much. But I guess a second question having to do with your kind answer is that it seems that it's more a response to a threat that the adjacent government is suffering more than an initial act of either threat or use of force. Wouldn't that be true?
Your Excellency, I believe you might be referring to the reaction of the Rosazan government from the armed gangs that are currently encamped within Rosasa.
That's correct.
So we do submit that this is not, or this does not fall under the exception of Article 51 of the Charter to constitute as lawful self-defense that would preclude the unlawfulness of use of force. And that is because in the jurisprudence of the court, it has been made very clear that the use or the right to exercise self-defense is against an armed attack by states against other states. Now, we do not have any evidence from the Statement of Agreed Facts that these armed gangs are actually directed or controlled by the Ottawan government, or that there is any sufficient link between the Ottawan government and the armed gangs. And thus, we submit that under the concept or the core concept of self-defense under Article 51, which has been reiterated by this court.
It may not be performed by the government, but it's tolerated by the government, isn't it?
Your Excellency, if I might respectfully defer from the toleration, we are not tolerating armed activity on our territory. In fact, we are actually condemning it because we have attempted to cooperate with the Rosazan state, for example, by establishing a task force of cooperation between police forces of both parties in order to combat the activities or the criminal activities of these armed gangs. In fact, the wall was originally envisaged for apprehending and deterring criminals in both of our territories. So we submit that the threshold of toleration or even support is not met in this case in order to warrant the responsibility of the Ottawan state for failing to prevent their territory from being used against the Rosazan state, much in the way that this court held, for example, in the armed activities case. So we would submit that the actions of Rosasa are not covered by a lawful use of self-defense, and further, they violate or they interfere with Ottawa's obligations to protect its own territory and to uphold the obligations contained in the International Covenant for Civil and Political Rights. Because under the covenant, Ottawa, as a party to that treaty, is under an obligation to protect the right of life, the right to human dignity, and the right to privacy of the people that are found within Ottawan territory. Now, this deployment directly interferes with the fulfillment of that obligation because the use of force that could potentially be used on Ottawan soil is not controlled or was not consented by the Ottawan state. Now, in my remaining time, I will briefly turn to the question of what
I would like to ask you, Agent. It is important to make the difference between law enforcement force or actions and military force.
For the purposes of the applicable framework of international law, certainly, Your Excellency, we do submit that the applicable framework for this context is that of international human rights law and is covered by, for example, the basic principles of law enforcement officials and the code of conduct of law enforcement. So we do submit that sometimes under this 1970 Code of Conduct, which was adopted by the United Nations General Assembly, the activities of or deploying the military, they might fulfill functions that are ascribed originally to law enforcement. So in our submission, we have to consider the activities of the Rosazan Army as those of law enforcement because we are not applying international humanitarian law to this context. And this is something that the respondent has agreed in its written submissions to the applicability of this regime. So this is why we are submitting obligations under the covenant.
And your country participated in the signing of the wall this autonomous weapon system, and with resources, even with engineers, well, you were the 4 members of the Cruceanian states withdrew and Rasasa and Arawa keep on with the commitment to build the, well, not the wall, this system. I know. And when you withdrew, yes, you said that it was for political and funding reasons, and you were admitting that it was okay to have this system. So why now?
So if I may respectfully defer from the characterization of agreement, Your Excellency, we do know from paragraph 26 of the Statement of Agreed Facts that when the wall or the project was concluded, the states affirmed or they manifested their satisfaction with having been involved. However, they stated that it would be neither economically feasible nor politically desirable to go further with the project. Now, we do know that Ottawa had a team of government and private sector engineers and devoted funding to the development of this weapon. However, the statements made by the Ottawan team cannot bind the Ottawan state in the form of acquiescence or authorization of having this weapon developed or deployed against its territory. And that is based essentially on the formulation of the nuclear tests case, Your Excellency, where there are unilateral statements that might bind a state. However, we submit that this is not one of those statements, particularly because we do not know from the Statement of Agreed Facts the character of the person who is making this statement. Now, we do concede that Ottawa made affirmations stating that the wall was, quote unquote, infinitely more reliable than human police or soldiers. However, Your Excellencies, between the time that the weapon was developed to the time that it was purchased and deployed by Rasasa, there was a fundamental key change in circumstances that would at least warrant additional review by the Rasasan government. And that is that the wall was originally envisaged to deter and apprehend criminals that were guilty of crimes such as vandalism, petty theft, or even some measures of assault. However, we do know that there is a report from the United Nations Office on Drugs and Crime that the previously unorganized militias had now become a sophisticated organized group that engaged in the trafficking of illegal drugs. And in combination with this fact, we do have allegations or very credible concerns to the company that developed the wall and the CEO, Ms. Darren Gray, that they have allegedly been engaged in supplying these kinds of technologies to paramilitary groups and other non-state actors in conflict zones. So this is what we would call, Your Excellencies, a recipe for disaster. Indeed, we are putting forth that even though the circumstances when the wall was developed were fundamentally different from the moment in which it was deployed, and it is not reasonable and indeed presents additional dangers for the populations of both territories to have an autonomous weapons system in such proximity to a non-state actor that is engaging in transnational cross-border crime. As I note the time, Your Excellencies, I will brief...
I think I would wish to ask you something else that has to do with the fact that the wall has been described as fully autonomous and as independent of human control. Now, would you consider that there is a need for a minimum level of human control to ensure that the autonomous weapon system is consistent with international law? And if that is so, could you provide us with precedents that may help us to understand the sort of rules and perhaps an emerging international, customary international law that may help us to understand the need for that human participation in this autonomous system? Thank you.
Mr. President, I see that my time has expired. May I briefly answer your question and then
please
conclude?
Please do.
Thank you, Mr. President. So, yes, we do ascribe to the view taken, for example, by the Special Rapporteur on Extrajudicial Killings, Professor Christoph Heinz, and the civil society organization campaign to stop killer robots, in that autonomous or fully autonomous weapon systems, the wall being the first of its kind, do need a degree or a minimum degree of meaningful human control in order to be considered lawful under either law enforcement or compliant with international humanitarian law. And that is because the necessary precautions that must be taken in the interest of protecting collateral damage or other persons that are not being targeted in an attack must be the result of cooperation between the machine and a human being. Currently, Your Excellencies, the wall does not have any power, or it cannot be overridden by any human actor. It makes decisions independently of any human control. We do ascribe to the emergent rule of customary law, of that of meaningful human control, and we do submit that meaningful human control would be the possibility of aborting the mission or overriding an attack in case that the wall makes a mistake. We would point, for example, to the 1955 preemptive ban on blinding lasers, for example, Your Excellencies, or the ban or practice, for example, in the demilitarized zone between North and South Korea. The robots there do have some level of autonomy, however, they do require that a human operator authorize each and every single instance of attack. I note the time, and if I can be of no further assistance to the court, this will conclude my submission. Thank you.
You're very kind. Thank you very much.
Thank you.
Shall I call to the next speaker for counsel of the applicant? Please proceed.
Mr. President, may it please the court. As introduced by my co-agent, my name is Rondas, and I appear before this court on the behalf of the applicant, the state of Ottawa. Duty, Your Excellencies, is one and invariable. It requires no impossibilities, nor can it ever be disregarded with impunity. On that note, I will be presenting the last two issues of the statement of agreed facts. First, Rasasa's tariff imposition, and second, Ms. Darian Gray's arrest and detention. Your Excellencies, the first issue revolves around the fact that both Ottawa and Rasasa are parties to the treaty establishing the Crucinian-Helian community, a treaty which, in its third article, prohibits the imposition of customs duties on helium products. However, Rasasa has done so. Your Excellencies, one cannot have security at the expense of the other's insecurity, and in this case, Rasasa's helium market cannot have economic growth at the expense of the other nation's economic growth.
I'm sorry to interrupt, but do we have jurisdiction to hear that point?
Yes, Your Excellency. However, we note that Respondent has made objections to the jurisdiction of the court. It is our position that this court does have jurisdiction, and if this court pleases, I will explain why. First, it's important to note, Your Excellencies, that Rasasa's main objection to jurisdiction is based on the fact that there is currently a parallel proceeding before the dispute settlement body of the WTO. However, Your Excellencies, as it has been found by this court on the pulp mills case, two parallel proceedings can exist at the same time. In that case, a proceeding before the ICJ and another before Mercosur could exist at the same time because the rights invoked were different. In this case, it is our position that the rights invoked are different because they are deriving out of different treaties. Before the dispute settlement body, Ottawa was claiming its rights under the General Agreement on Tariffs and Trade to zero bound rates on helium products. And before this court, Ottawa was claiming its rights under the treaty establishing the Crucinian-Helian community to the health and development of the helium industry.
Excuse me. I would like to ask you, what happens if we recognize this jurisdiction and WTO has a resolution and it contradicts ours? Which one will prevail?
Your Excellency, I will address your first question, which is what happens if this court does not recognize the jurisdiction. That would basically entail that the provisions contained within the CHC Treaty that are safeguarding the health and
But I ask that we do recognize the jurisdiction.
Apologies, Your Excellency.
Yes, and then we get to know about the case, and also the WTO, they have a resolution, and when we have the resolution, it's in contradictory. So what do we do in that case?
Your Excellency, in this case, although there exists a possibility for contradictory rulings to be reached, it wouldn't pose any threat or danger to the international law, because in this case, the claims are deriving out of two different treaties. Before the dispute settlement body is deriving out of the General Agreement on Tariffs and Trade, and before this court out of the CHC Treaty. And as it has been found by this court on the genocide case, one same legal fact can give rise to a variety of violations under different bodies of law. So let's put an example that the dispute settlement body were to rule that the tariffs are lawful under the GATT, but this court were to rule that they are unlawful under the CHC Treaty. Rasasa would still be under the obligation to remove the tariffs, as they would be in contravention of one of their obligations contained within the CHC Treaty.
What about the argument about the national security? The treaty establishes it.
Yes, Your Excellency, we do note that Article 22 of the CHC Treaty provides an exception for the rule contained in Article 3 that requires the measures imposed are to protect essential security interests and that they are necessary. However, Your Excellencies, the treaty does not provide any definition for these two terms. First, relating to the essential security interests, we must take a look at the report provided by the International Law Commission on State Responsibility, which states that essential security interests relate to the political stability of its state and the maintenance of internal peace. In this case, it is our position that the imposition of tariffs by Rasasa could not have possibly be made to protect either the political stability of the state or the maintenance of internal peace. As for example, they may argue that the tariffs were derived out of Ottawan gangs crossing into Rasasan territory. It's important to note that since the wall was deployed and before the tariffs were imposed, transborder crime was reduced by 80%. So Rasasa cannot allege that the protection of essential security interests is valid. Second, Your Excellencies, do I sense your concern, Mr. President?
Yes, the point I wish to make is that of who is to decide whether or not we are really facing a matter of essential security interests. In the case of the GATT treaty, there is a list of issues that provide a criteria for the determination of when security interests are being affected, which I think is an important matter that has to be taken into consideration when determining whether by the state itself or by an external entity, which has happened in more than one instance, for example, in the case of the International Court of Justice, to define whether essential security interests are being affected. Now, in this particular, well, let me add that in the case of NAFTA, the same is true. There is a chapter on essential security interests, but again, there is a determination of when and how, and you have mentioned some already, that can happen. Unfortunately, in the case of TEMEC, that doesn't happen. Those 3, 4, 5 criteria that were before in the NAFTA treaty are no longer there. But my main point has to do with whether one of the parties in the treaty would be able to decide that their essential security interests are being affected, or whether there should be an external entity, such as the International Court of Justice, to decide whether or not those essential security interests are being affected.
Certainly, Mr. President. In this case, Article 22 of the CHC Treaty does not provide whether the declaration that there is an essential security interest must be done by the state or by a court. And in this case, it is our position that Rasasa can make that determination. However, it is subject to the review of this court. And also, attending to your concern about the definition of essential security interests in the General Agreement of Tariff and Trade, there is a ruling recently made by the WTO, the Russia Concerning Traffic and Transit case, in which is stated that even if states are acting to protect their essential security interests, they must do so in line with the object and purpose of the treaty. In this case, Your Excellencies, deriving out of Articles 1 and 3 of the CHC Treaty, we provide that the object and purpose of the CHC Treaty is the health and development of the helium industry, and in this case, Razas tariffs are affecting the health and development of the helium industries of the other proscenium states. Your Excellencies, now turning to the definition of necessary, the treaty also does not provide a definition for what necessary is. Thus, according to customary rules of interpretation, we must take a look at the ordinary meaning awarded to this word, which in this case is something indispensable for achieving a certain purpose. In this case, Razas' purpose by the imposition of tariffs is the boost of the helium market. However, Your Excellencies, these measures were not indispensable, as they were not the only ones that Razas could have taken to boost its helium market. In this case, I may point the court to what Brazil did in 2012 to boost its vehicle innovation technology market, in which it imposed a tax program which rendered results in only a year, which is around the same amount of time that the tariffs have been in place. This is why, Your Excellencies, we put forth before this court that Razas' tariffs are not necessary, neither there is an essential security interest to protect.
I ask you, Counsel, you indicate that it's not necessary because there's options, but doesn't that beg the question? Necessary means that there's a reason justifying it. The fact that there's options means that there might be other reasons justifying it or other routes you can take. Isn't there or what would you answer to this concern?
Certainly, Your Excellency. However, as well as with the essential security interests, that they need to be in line with the object and purpose of the treaty. The meaning of necessary also needs to adapt with what the object and purpose of the treaty is. In this case, Razas' helium industry may grow as a result of these tariffs. However, the other economies of the other states will diminish as a result of these tariffs, which goes in contravention to the object and purpose of the CHC Treaty.
So it's not necessary because it defeats the purpose of the treaty?
It's not necessary because it defeats the purpose of the treaty and because there are other options that Razas could have taken, Your Excellency.
Less onerous options, say so nice.
Excuse me, Your Excellency.
Less onerous options, I assume?
Perhaps, Your Excellency, I cannot instruct the court in that regard. However, there are other options that Razas could have taken.
Thank you.
Your Excellencies, if you have no further questions, I'd like to move on to Ms. Gray's arrest and detention. Your Excellencies, this issue revolves around the fact that Ms. Darian Gray is accused to have committed war crimes between the years of 2007 and 2009 in the island state of Garantia, a state which is a party to the Rome Statute. As a result of this, the International Criminal Court initiated an investigation, which ended with the issuance of an arrest warrant against Ms. Darian Gray. However, when Ottawa served this arrest warrant, Razas protested as an internationally wrongful act. Your Excellencies, the greatest incentive for crime is based on impunity, and this is why I will first explain why the International Criminal Court has jurisdiction to try Ms. Gray over her alleged crimes, and second, why Ottawa could have arrested her and her arrest didn't constitute an internationally wrongful act, as she didn't enjoy any diplomatic immunities. Your Excellencies, the ICC has jurisdiction over this case because, as I've mentioned before, her crimes were committed in the state of Garantia, a state that signed and ratified the Rome Statute, which, by virtue of Article 12.1 of the statute, recognizes the jurisdiction of the ICC. Further, Your Excellencies, this jurisdiction was formally triggered when Garantia referred the situation to the prosecutor of the ICC under Article 13.1 of the Rome Statute. Your Excellencies, in this case, I'd like to paint a picture. I'd like you to imagine the ICC as a giant who has the ability to rid the world of the most serious crimes of international concern. However, Your Excellencies, this giant has no limbs. It requires the cooperation of its states members in order to fulfill its purpose. In this case, this is contained under Article 86 of the Rome Statute, which establishes a general obligation to cooperate with the ICC. Thus, by arresting Ms. Gray, Ottawa was fulfilling its obligations under the Rome Statute. Your Excellencies, Respondent contests that this was an internationally wrongful act because Ms. Gray enjoyed diplomatic immunities at the time of her arrest. However, we differ from that position because, although Article 32 of the CHC Treaty may grant immunities to foreign representatives while attending the meetings and in their journeys to and from their places of meeting, Ms. Gray no longer fell under what's established by Article 32, as she was arrested one day after the CHC meeting had ended. Thus, she no longer enjoyed the immunities that this article confers. Your Excellencies, we agree that this may seem as a construed interpretation of the treaty. However, we still put forth that it is in good faith, as it doesn't defeat the object and purpose of that article, which is to allow member states to have a representative before the meeting. Ms. Darren Gray was allowed to represent her state before she was arrested.
Could I quote a decision of the International Court of Justice on these matters of arrest warrants, an important case because of the Congo and Belgium? The court in 2002 indicated that the functions of a Minister of Foreign Relations are such that throughout the duration of his or her office, he or she, when abroad, enjoys full immunity from criminal jurisdiction and inviolability. That immunity and that inviolability protect the individual concerned against any act of authority of another state which would hinder him or her in the performance of his or her duties. How would you reconcile this statement, which has been consistently reiterated by the International Court of Justice, with what the International Criminal Court indicates? Is there a conflict of jurisdictions, of substantial rules of international law between one court and the other?
In this case, Mr. President, in the arrest warrant case, it's important to make the distinction that when the court emitted that ruling that Minister for Foreign Affairs enjoyed immunity from the jurisdiction of another state, Belgium intended to prosecute before its own tribunals the Minister for Foreign Affairs of the Democratic Republic of the Congo. In this case, Ms. Grace intended to be tried before the International Criminal Court, and the ICJ, in precisely the arrest warrant case, states that any immunities attached to the office of a Minister for Foreign Affairs cannot apply before international tribunals. And the court even went as far as naming the International Criminal Court as one of those tribunals where immunities could not apply. This is why, Your Excellencies, we are putting forth that Ms. Gray did not enjoy any diplomatic immunities at the time of her arrest.
Excuse me, Agent. Do you remember what the Article 32 established in the Treaty of the Carcinian Helian Community?
Yes, Madam President. Would you like me to quote the article?
Yes, please.
Your Excellency, Article 32 states, representatives of member states at meetings convened by the community shall, while exercising their functions and during their journeys to and from the place of meeting, enjoy immunity from personal arrest or detention and from seizure of their personal baggage, and in respect of words spoken or written, all acts done by them in their official capacity, immunity from legal process of any kind.
Okay, and now do you remember what the Rome Statute establishes in the Article 97 and 98 regarding consultations and comparison?
Certainly, Your Excellency, we do recognize that Article 98 of the Rome Statute bars essentially the ICC from requesting assistance to a state if that request for assistance would mean that the state would breach its international obligations towards a third state not party to the Rome Statute. However,
so is Adawa in breach of this agreement, right?
No, we respectfully disagree, Your Excellency, because, as I've stated before, it is our position that Ms. Gray no longer enjoyed the immunities conferred by Article 32 of the CHC Treaty. And, for example, the immunities conferred to Ms. Gray by Article 29 of the Vienna Convention on Diplomatic Relations, those immunities have been stated by this court that they cannot apply before.
Adawa and Rasasa are not part of this convention, are they?
Adawa and Rasasa are part to the Vienna Convention on Diplomatic Relations, Your Excellency. So,
I query whether if we accepted your proposition that because the minister did not come immediately back, but until the next day, her scope of immunity would have lapsed. If I understand your argument correctly, it means that if you attend an official event, your immunity will lapse unless you immediately come back. Understanding by immediately, not more than 1 day. Is that a workable rule? You think it's a fair reading of that statute?
Your Excellency, in this case, it is our position that this interpretation does comply with the object and purpose of that precise article, as we can note that the arrest warrant was issued by the International Criminal Court on the 20th of June. However, Ardwan police waited until the 22nd of June to arrest Ms. Gray because the convention ended on the 21st. Thus, they waited until their immunities were over, so to speak. Your Excellencies, further, we have the submission to make that both parties to this dispute are also parties to the 4 Geneva Conventions, which, in, for example, Article 49 of the First Geneva Convention or Article 50 of the Second Geneva Convention, establish a general obligation to either extradite or prosecute any war criminal or alleged war criminal that is found in the territory of a state party to the Geneva Conventions. Your Excellencies, by arresting Ms. Gray and extraditing her to the International Criminal Court, Ada was complying also with this obligation contained within the Geneva Conventions. As also, we put forth before this court that the prosecution of war crimes should be considered as a jus cogens nature. This, for example, can be derived from the jus cogens nature that this court has awarded to the Genocide Convention, which has essentially the same interests as the Rome Statute, which is to rid the world of this type of crimes. Thus, Your Excellencies, even if Ms. Gray were to have enjoyed immunities, she could still be prosecuted because the prosecution of war crimes is jus cogens. And as was found by an ALC report and the European Commission of Human Rights, the application of jus cogens norms shall always prevail over any other source of international law.
But don't you think it's going a bit too far to say that Foreign Minister Gray is a war criminal? Has that been proven? Are there sufficient grounds to consider that she has committed serious crimes against humanity, for example? Would you be ready to affirm that she is a criminal, a war criminal?
No, Mr. President, we wouldn't make the affirmation that Ms. Gray is a war criminal. However, she's an alleged war criminal, and she should be treated as such, because Ms. Gray is alleged for committing war crimes, not running a red light, or... Mr. President, I see my time has... May I briefly conclude?
Finish.
Thank you. Ms. Gray is investigated for war crimes, not for getting a parking ticket or running a red light. This is why this should be treated very carefully. If this court has no further questions, this will conclude my submission. I thank you for your time.
Thank you. Thank you very much indeed. Now I call counsel for the respondent to submit the views of the respondent. Thank you.
Mr. President, Your Excellencies, may it please the Court. My name is Eduardo Fragoso, and alongside my co-agent Brian Sanchez and Fernando Reas of Counsel, we will plead on behalf of the respondent, the Republic of Rasasa. For the next 21 minutes, I will address the first submission, that this Court lacks jurisdiction since Aragua is not a party to the 1929 Treaty of Bottega, and the second submission concerning that Rasasa's development and deployment of the weaponized autonomous limitation line is consistent with international law. My co-agent will address the third submission, that Aragua's claim is inadmissible, and the fourth one concerning the arrest and detention of Minister Gray as inconsistent with the international obligations of Aragua. We respectfully reserve 2 minutes for rebuttal. Your Excellencies, the issue before this court is an issue about the protection of the core elements of international law: consent, good faith, and the freedom of states. It was the contention of the applicant that this court has jurisdiction since Aragua is a party to the 1929 Treaty of Ortega. However, it failed to provide an article within the statute of this court to establish the jurisdiction. We, as the respondent, establish that any possible assessment of the jurisdiction of this court has to be made in accordance with Article 37 of the statute of this court, that establishes that when we are in front of a compromissory clause providing a specific referral to the Permanent Court of International Justice, may provide jurisdiction to the court. And in the Barcelona Traction preliminary objections, this court recognized that we need three elements for this court to have jurisdiction. First, that we need the compromissory clause with the specific referral to the Permanent Court. Second, that we need that the parties to the dispute are parties to the statute of this court. And third, that we need that the treaty has to be enforced between the parties. As the respondent, we concede that the first two elements are met, since both parties are parties to the statute of this court since 1949, and second, that we have indeed in Article 6 of the Treaty of Ortega a specific referral to the Permanent Court of International Justice. However, we are contending that the treaty is not enforced between the parties because Adawa did not succeed to the Treaty of Ortega from the dissolution of the Adawa-Saitunian Union. And as this court recognized in the preliminary objections of the aerial incident case of 2000 between India and Pakistan, it was established that the court did not have jurisdiction in accordance with Article 37, because India never succeeded to the General Act of 1928 for the Pacific settlement of disputes. And we're establishing that as an exclusive ground that there is no customary rule of automatic succession such as the one that the applicant submitted. Your Excellencies, in law, nothing is automatic. And we're advancing that the rule that the agent for the applicant claimed that it is established in Article 34 of the Vienna Convention on Succession of States is not a customary rule. And since the parties to this dispute are not parties to that convention, the rule is not binding. But in respect of the customary value of this rule, if we go, for example, to the situation of Yugoslavia, when Serbia was the successor of Yugoslavia, it had to conclude subsequent agreements with the other states that have bilateral treaties with its predecessor, Yugoslavia. And in the case of the Second Slovak Republic, it was recognized, for example, by an arbitral tribunal in the European American Investment Bank versus Slovakia that the bilateral investment treaty that provided jurisdiction to that tribunal was only binding upon Austria and Slovakia at the moment of an exchange of diplomatic notes between Austria and Slovakia, recognizing and consenting the succession of Slovakia from the treaties that signed and ratified its predecessor. Thus, we're in the position to conclude that we are not in front of a customary rule of automatic succession in cases of dissolution.
Let me go to a different point regarding jurisdiction. As far as we know, it has been agreed by both parties that a dispute between them exists. And it has also been agreed that the claim and counterclaim will be part of the procedures before this court. Now, the counterclaim will be governed by Article 80 of the Rules of Court. Now, let me read what it says. It says, a counterclaim may be presented provided that it is directly connected with the subject matter of the claim of the other party and that it comes within the jurisdiction of the court. Wouldn't you say that there is a contradiction with this objection to jurisdiction, because somehow you have already accepted to submit a counterclaim, and according to Article 80, which governs somehow the whole procedure, is that it comes within the jurisdiction of the court. How do you explain this matter? And of course, I would wish also later on to make some reference to the question of state succession and the jurisdiction of the court. Please proceed.
Mr. President, your question will allow me to move to the second point in this first claim, that even if we accept that we submit counterclaims in accordance with the case that was mentioned by the applicant in respect of right minorities in Upper Silesia, and in respect of what this court declared in the preliminary objections on the Anglo-Iranian Oil Corporation preliminary objections, it was established that a submission of a counterclaim may amount to a tacit consent of the jurisdiction. However, it has to be an objection to the jurisdiction to bar that tacit consent. And moreover, in the Anglo-Iranian case, the court declared that the submission of counterclaims when we are in front also of an objection to jurisdiction cannot be taken as a consent to the jurisdiction, because the counterclaims have to be taken as ad cautelam, since they are a measure of defense for the respondent if the court recognizes that it has jurisdiction. And we are presenting the counterclaims in respect of the lawfulness of the wall and in respect of the unlawful detention of Minister Gray ad cautelam in case this court recognizes that it has jurisdiction.
We have any questions? I have an additional question which has to do with state succession. Because I noticed that in the area of state succession with respect to treaties specifically, the move in international relations is towards a greater, not a lesser, continuity of treaty rules. For example, in the case of the International Court of Justice, again, in the Gapchico-Naguimaros case, it indicated very clearly that Article 12 of the Vienna Convention on the Succession of States in respect of treaties, and I quote, reflects a rule of customary international law. The same is true in the case of the International Law Commission, which has also reiterated that the state practice is consistent to support the rule that treaties in force at the date of dissolution should remain in force ipso jure with respect to each state emerging from the dissolution. Now, I think that to disregard this notion that this rule exists may complicate the whole issue of state succession if you are somehow entitled to renounce obligations that are contained in the treaty itself.
Mr. President, we do recognize that there are some other rules that might apply in cases of a state succession. For example, the rule that was addressed by this court in the Gapchico-Naguimaros case in respect of territorial treaties is a customary rule of international law, but that rule provides that when we're in front of a treaty that there is creating an objective regime in a specific area, then we could have a succession. However, in the present case, the treaty does create this kind of a special regime in the International Zone of Peace created. However, in the Gapchico-Naguimaros case, it was also recognized that Slovakia was the legal successor of Czechoslovakia in respect of the Gapchico-Naguimaros Treaty, but only because the special regime created in that treaty was in the territory of Slovakia. And in the present case, we're advancing that the successor is not the state of Ottawa, but the state of Zaytunia, since the International Zone of Peace is established within the territories of the Republic of Rasasa and the government of Zaytunia. And we're establishing that the treaty is enforced but only between Zaytunia and Rasasa and not Ottawa, and therefore Ottawa is not entitled to claim any legal rights and obligations in that treaty because, and moreover, and more important, the compromissory clause established in Article 6 that will provide jurisdiction to this court. And since we indeed accept that there is a rule of automatic succession, that rule is only established in the Vienna Convention on Succession of States, and it is not a customary rule that could bind states that are not parties to it, and this follows the trend of what is recognized in the North Sea continental shelf cases, that when states are not parties to a treaty, the treaty cannot bind those states. Should this court recognize that it has jurisdiction, the second contention of the respondent is that the development and deployment of the weaponized autonomous limitation line is consistent with international law. Your Excellencies, states have the sovereign right to protect and secure their borders. However, the respondent also recognizes that this right is limited to comply with other rules of international law, and this follows the same trend of what the European Court of Human Rights recognized less than a month ago in the case of ND and NT versus Spain, in which it was established that states have the sovereign right to protect their borders. However, this right has to be in accordance with other international obligations, such as human rights and general international law. And we established first that the wall is complying with the general prohibition of the threat or use of force. Before moving to this first ground, I want to make a precision that the applicant said that we're in front of an unlawful use of force, and it resorted to the fact that there were warning shots issued by the wall. We recognize that there were warning shots. However, we don't have any information provided to the parties or that we could provide to this court that the shots were within the territory of Adagua. We don't have, at this moment, the factual elements to prove a use of force. However, we recognize that any possible unlawful measure of the wall had to be assessed in accordance with the threat of force. Article 2, Paragraph 4 of the United Nations Charter establishes that state members should refrain in international relations from the threat of force when it might affect the political independence or the territorial integrity of other states. And Professor Sir Ian Brownlee established a standard to determine if we're in front of a threat of force. First, that we need an express or implied promise to recourse to force. Second, that we need the element of coercion. And third, that this has to be between states. In respect to the first element, an express or implied promise, it was recognized by the Permanent Court of Arbitration in the Guyana versus Suriname case that in that case we have a threat because the agents, the naval officers issue radio threats to the ships of Guyana, saying that they will deploy force if they not refrain from entering into its territory. If we resort to the facts of the case, in paragraph 37 and paragraph 39, these measures were taken only to protect and secure borders. They are not a direct threat neither against Adagua nor any other state. It's not a threat against its citizens, and it is not a threat to recourse to force. And if we move to the second element, the element of coercion, this goes in accordance with what this court recognized in the Corfu Channel case, that the operations made by the British Navy ships were not taken to produce any sort of political pressure upon Albania, but that were a reasonable measure due to the constant attacks that the ships suffered. In the present case, the wall is not deployed there to cause any political or social or economic pressure upon Adagua. It's established there because it is the reasonable measure to take after the regrettable attacks of the gangs that not only killed border patrol officers, but that they killed people of Rasasa, citizens, and the damages of the illegal actions of those gangs are the ones that have us here to talk about the right of a state to protect its borders. And in respect of the last element, this is not a matter between states, and as the applicant recognized, these are law enforcement measures, meaning that these law enforcement measures are not measures to attack the states or the international community. These measures are to protect and secure borders. And
Excuse me, Agent. I would like to ask you, in support of your argument, I don't know if you're acquainted with the case of Hernandez-Huereca and the resolution of the Supreme Court of the United States. So according to the Article 38 of the Statute of the International Court of Justice, is the domestic law, or in this case, the resolution of the U.S. Supreme Court, we should take it into consideration to resolve the case?
Your Excellency, we as the respondent regret what happened in that case, and we recognize that judicial decision might help to discuss the issues in this case, and that will help us to establish that Rasasa is taking all the possible measures that it has in accordance with the due diligence obligation to avoid a violation of international obligations, because the wall was tested. The wall has the capability to assess if it is in a real threat that could warrant a response of a deployment of lethal force. And also, Rasasa established hotlines between the two states that will provide citizens of Rasasa and Adawa to express their concerns in respect of the wall. And we could resort to the clarifications paragraph 4 that mentions that the wall had the opportunity in 100 times to deploy lethal force. However, the court decided in 100 of those 105 to issue verbal warnings, and in the other 5, it only issued warning shots. And at this moment, there is no injured or killed person by the actions of the wall. We could move that this is a law enforcement measure, but also it was a contention of the applicant that we were in violation of international humanitarian law. However, we're establishing that...
Sorry to interrupt you, but in the previous intervention by counsel of the applicant, it was said that it was no longer a threat of use of force, but that action has been taken already to use force against citizens of the applicant's country. What would you say about that?
Mr. President, as it was recognized by the International Law Association in its resolution of London in respect of the use of force, it was established that a law enforcement measure could amount to a use of force, but only when there is a level of intensity in the violence that could amount to this use of force, an unlawful use of force. However, as it is established in the clarifications, there is at this moment no killing and no injured person, and moreover, the warning shots that were submitted by the applicant as a proof of a violation of territorial integrity or as a proof of a use of force cannot be established, since at this moment we don't have information that the warning shots were affecting the territory of Rasasa nor its citizens. To briefly conclude, in respect of international humanitarian law, we're establishing that Rasasa complied with its obligation to assess the lawfulness of a new weapon before its use. This customary obligation establishes that a state is obliged to make an assessment of a wall before deploying it, and it will resort to paragraphs 23 and specifically to paragraph 23 of the Statement of Agreed Facts. It is established that Rasasa made an assessment of the wall in accordance with international law. And in paragraph 25 of the Statement of Agreed Facts, it is a declaration made by the head of the team of Adawan experts that declare that the wall has a 0.001 margin of error in respect of deployment of lethal force, meaning that in 1 of 1 million encounters, the wall will only fail in that one encounter in respect of deployment of lethal force, meaning that it will be more easy to be struck by a lightning than to be attacked by the wall, because the wall has this level of effectiveness. And in respect of a second ground issued by the applicant, that the lack of meaningful human control is a violation of customary international law. First, it was recognized by this court in the advisory opinion of nuclear weapons that the lawfulness of a new weapon has to be assessed, but not in the terms of a lack of permission, but in the terms of recognizing if we indeed have an express prohibition. In the present trend of international law, we don't have a customary prohibition in respect of weapons with this autonomous function, and we also have practice of states that are using autonomous weapon systems to protect their borders. For example, we have the cargo robot in Turkey, we have the Harpy robot of Israel, we have the Phalanx system by the United States, and we have also India that is developing this technology. And we could resort to what the General Comment 36 in respect of Article 6 of the International Covenant on Civil and Political Rights established in its paragraph 65. That the development and putting into operation of an autonomous weapon system is unlawful unless it complies with international obligations. the wall is not a threat or a use of force that is unlawful under international law, is not violating international humanitarian law, and it is a measure that is helping both states to secure and protect and to strengthen the relationship that they are sharing as neighbor states, because that is the importance of this case, to protect not only the rights of a state to protect their borders, but to also protect their other states. May it please the court.
Mr. President,
Thank
would
you.
mind if I make a quick
Yeah,
question?
by all means, by all means.
I didn't want to interrupt your interesting argument. You characterize the wall as a law and order measure. Would you agree that a threat exists when somebody fears that something will occur?
Your Excellency, even if we could recognize that as a threat, and there were some concerns made by the citizens of Rasasa and also by the state of Adagua as a whole, we are in the position to say that the wall is not a threat, but not based only in the examination of the wall before its use, but also in respect of the effects and the legal standards that the wall is following.
Doesn't it instill fear
It-
in a neighboring country?
Of course that an autonomous weapon system might sound something frightening, and it could be more to a thing of the culture, but we're establishing here not only with the practice of Rasasa, but with the practice of other states, that the wall is complying, and that we're in a new stage of the development of security between states, and maybe a measure that is going to help to protect more humans and to establish that states have the accountability measures to establish that we are not in front of violations of human rights.
Thank you.
May it please the court.
Thank you. Thank you. Shall I call the co-agent for the respondent to come to the floor?
Mr. President, Your Excellencies, may it please the Court. My name is Ryan Sanchez, and for the next 22 minutes, I will address the third and the fourth claim. The third concerning the inadmissibility of Adawa's claim, and in the alternative, that the imposition of tariffs on Hyang hyacinth products is not in breach of the CHC Treaty, as well as the fourth claim concerning that Adawa's arrest and detention of Minister Darren Gray is being contrary to international law. First, turning to my third claim, we submit that this court cannot adjudicate this case due to dispendence. The customary rule of dispendence, in which we can find as it practiced in the juris, for instance, in the civil procedural codes of Canada, Germany, Russia, India, as well as in international conventions, such the case of the optional protocol of the International Covenant on Civil and Political Rights, as well as the Convention Against Torture. And in these main instruments, there are three requirements in order to apply dispendence. First, the existence of parallel proceedings before two international fora. Second, that these parallel proceedings have the same subject matter, and besides the same subject matter and the existence of parallel proceedings, these proceedings have to be the same parties. This is confirmed by the Mox Plan case brought before the Permanent Court of Arbitration in the year of 2003 between Ireland and the United Kingdom, where the United Kingdom argued that as consequence of the existence of another parallel proceeding before the European Court of Justice, which involved the same parties, Ireland and the United Kingdom, and the same subject matter that was the Mox Plan case, the Permanent Court of Arbitration had to suspend its proceedings. Therefore, the Permanent Court of Arbitration decided to suspend its proceedings in order to precisely avoid conflict of judicial decisions. Now, turning to the facts of the case, in accordance with paragraph 47, Adagua requested the establishment of a panel before the World Trade Organization, alleging that Rasasa's imposition of tariffs were against its obligations. But after that, Adagua, in accordance with paragraph 57 of the Statement of Agreed Facts, instituted proceedings before this court alleging the same subject matter, that was the illegality of the Rasasa's imposition of tariffs against its international obligations. Since these requirements in order to apply less spendings are met, in this case, we maintain that this court cannot adjudicate this case.
So sorry to interrupt you, but the main issue has to do with the settlement of disputes, both in the case of the World Trade Organization and in the case of the International Court of Justice. Now, the problem is that there seems to be absolutely no hope that the World Trade Organization will be able to settle the dispute. The fact is that, unfortunately, the system of dispute resolution in the World Trade Organization is not functioning at all. And the reason for that is the fact that the US has blocked the nomination, the appointment of members of the panel that is in charge of dispute settlement. So the possibility of having a resolution of the dispute by the World Trade Organization is really far beyond our hopes. The only possibility the parties have to settle their dispute right now is the International Court of Justice. I wonder what you have to say about this.
Mr. President, regarding the main concern about this actual situation of the World Trade Organization, it is important to mention that goes with the idea of my second submission, that in this case, the World Trade Organization has exclusive jurisdiction, and it is also important to mention that disregard of the main problems that has been occurred in the World Trade Organization, this is only concerns with the appellate body. But first, it is important to mention that in these cases, first it is important to given the factual basis in order that the panel of the World Trade Organization give its judgments. Now, as it is established by Article 23, Paragraph 1 of the Understanding of Rules and Procedures governing the settlement of disputes of the World Trade Organizations, member states of the World Trade Organizations have to recourse exclusively to the dispute settlement of the World Trade Organization. Now, in accordance with the statement of agreed facts, specifically at Paragraph 12, Adagua and Rasasa became members of the General Agreement on Tariffs and Trade. And after that, in accordance with Paragraph 57 and 47, Adagua requested the establishment of a panel before the World Trade Organization, alleging that the imposition of tariffs on Helian hyacinth products by Rasasa were in breach of its obligations. And that is why, in this case, we are submitting that since there is a dispute regarding violations to the World Trade Organization, the World Trade Organization has exclusive jurisdiction to deal with this matter. And this is confirmed by the measures affecting trade case brought before the panel of the World Trade Organization in the year of 2003, in which it was argued by Korea that as consequence of the non-compliance by the European communities of its obligations, the European communities have to recourse exclusively to the dispute settlement of the World Trade Organization. As consequence,
your point is basically a question of jurisdiction. My question has to do with settlement of disputes. Would you think that one of the losing parties in the first instance will not go to the appellate, will not try to go to the appellate body in order to have a recourse of appealing the first decision? I'm pretty certain that either of the two parties will do that, but then it will find it impossible to reach a decision on the part of the appellate body, which is the unfortunate thing that dispute settlement system in the World Trade Organization is just not functioning, which is very unfortunate.
Mr. President, in this regard, we maintain that even though there is certain crisis or even though there is certain problems in the dispute settlement of the World Trade Organization, the state parties of the World Trade Organization actually are doing all the taken measures in order to resolve this problem. And that is why first, we have to recourse exclusively to the World Trade Organization and to giving a report by the panel. And actually, that will help the main concerns of the agent of the applicant, because it is also important to mention that as it is established by the DSU settlement disputes of the World Trade Organization, a remedy that is given after the issuance of a report by the panel of the World Trade Organization is the obtaining of compensation. However, should this court recognize that it has jurisdiction or the case is admissible, we maintain that the imposition of tariffs on helium hyacinth products by the Republic of Rasasa is not in breach of the CHC Treaty. It is important to mention that even though that Article 3 of that specific treaty establishes that the states parties agree to impose no custom duties on helium hyacinth products, the same treaty has an exception in Article 22, where it is provided that member states can adopt measures necessary to protect its essential security interest. It is important to mention what does an essential security mean, and we can take recourse to the case brought by the agent of the applicant, the Russia tariffs and transit brought before the World Trade Organization in the year of 2019, specifically paragraph 7.130, in which it is provided that essential security interests are the quasi-essential functions of the state, and given certain examples, for instance, the protection of the population, the protection of the nation, as well as the maintenance of law and public order. Now, it is important to mention that that is also important that the necessary character is going to be with the achievement of a legitimate objective. Now, in accordance with the statement of agreed facts, specifically paragraph 30, it was published by a report of the Rasasa and Helium Growers Association that as consequence of the current trend between Adawa and Rasasa and the preference in the purchase of the helium hyacinth products to the Adawan farmers, the Rasasa and helium farmers were affected, and that indeed, if the current trends continue, the economy of Rasasa will collapse in 5 to 10 years. And it is also important to mention that in that specific report, it is established that not only the economy will be affected, but also the nation. And it is also important to mention what is established in paragraph 2 of the statement of agreed facts, as well as paragraph 1, that the helium hyacinth plant is one of the main elements for the economy of Rasasa. Now, as it is established by paragraph 33, these measures were established in order to protect the essential security interests of Rasasa, and specifically, these measures were in order to protect the economy of Rasasa that were suffering after the current situation and affection to the Rasasa and helium grower farmers. Now, it is important to mention also that should this court recognize that there is a breach of an international obligation, we maintain that in this case, it is not what is happening, because it was raised by the agent of the applicant that this can be acquired to compensation or to an international wrongful act. However, we can take recourse to articles on state responsibility, specifically Article 2, in which it is provided that an international wrongful act is only going to be constituted when indeed there exists a breach of an international obligation. In this case, it is not what is happening, since the imposition of tariffs on helium hyacinth products by the Republic of Rasasa is in accordance with Article 22 of that treaty, and as a consequence, Adawa cannot claim any consequence of that breach, namely specifically compensation.
You have mentioned the GATT rules which apply to the issue of essential security interests, but you may have noticed that in the listing of issues that may support the application of tariffs, for example, to protect essential security interests, the fact is that in the listing of topics that are included in the article of GATT, they only mention those that are related to fissionable materials, for example, or relating to traffic of arms, taking in time of war or other emergencies. And I don't see any mention to trade issues or commercial issues as the imposing of tariffs. So aren't you going a bit beyond what the rules establish, at least in the case of GATT?
Mr. President, allow me to disagree with you, because as it is established by Article 21 of the GATT, specifically in paragraph B at the point 3, These measures can be taken when there is the existence of an emergency in international relations. And that is what is actually happening in this case, because there are not only current criminal problems between the state of Ottawa and the Republic of Rasasa, but also there is an affection to the nation and to the economy of Rasasa. That is why we maintain that indeed we comply with the CHC Treaty as well as the GATT. Now turning to my first submission, first, it was raised by the agent of the applicant that in this case is about the obligations brought before the Rome Statute of the International Criminal Court. However, it is important to mention that in accordance with Article 13 of the Statement of Agreed Facts, Rasasa is not a party to the Rome Statute, and however, Rasasa cannot be bound in order to comply with that specific provisions. Moreover, this is an issue regarding the international obligations of Ottawa and Rasasa. It is established in accordance with paragraph 60 of the Statement of Agreed Facts that Ottawa and Rasasa are parties to the Vienna Convention on Diplomatic Relations of 1961. And it is important to mention that in accordance with Article 29 of the Vienna Convention on Diplomatic Relations, read it in conjunction with Article 32 of the CHC Treaty, Darian Gray enjoy immunity and inviolability which prohibit her arrest and detention. First, because enjoys functional immunity in accordance with Article 32 of the CHC Treaty, because when she was arrested and detained, she was a representative member of Rasasa in the meeting of the CHC, and that is why in that specific case, Darian Gray enjoyed the functional immunity as representative of Rasasa. But also it is important to mention that she enjoyed the personal inviolability granted by the Vienna Convention on Diplomatic Relations, because as it is established by the Statement of Agreed Facts, specifically at paragraph 32, Darian Gray was appointed as Minister of Foreign Affairs of Rasasa, and that only goes against the international obligations of Ottawa under the Vienna Convention on Diplomatic Relations, as well as the CHC Treaty. This is confirmed by the arrest warrant case brought before this court in the year of 2002, in which it is confirmed that Minister of Foreign Affairs as well as other high-ranking officials enjoy inviolability and immunity that prohibits their arrest and detention. Now, it is also important to mention that should Ottawa want to claim certain obligations under the Rome Statute, it is important to mention what is established in Article 98 of that statute, as well as Article 32 of the Vienna Convention on Diplomatic Relations, that in order to arrest and detain a high-ranking official, such as Minister of Foreign Affairs, a state have to obtain first the waiver of that immunity or inviolability, and in accordance with Article 32, this waiver has to be expressed. In accordance with the Statement of Agreed Facts, specifically paragraph 51, Ottawa arrest and detain Minister Darian Gray without obtaining first the waiver of the immunity in order to be able to do that specific act. Now, it is also important to mention that in accordance with what was raised by the agent of the applicant, these crimes are characterized as a jus cogens norms. However, we can take recourse by what was stated by this court in the arrest warrant case brought before this court in the year of 2002, specifically in paragraph 93, in which it is precisely determined that there is not a conflict between the jus cogens norms and the immunities, because immunity does not mean impunity, and moreover, even though that there existence of a jus cogens crimes, that does not deprive a state in order to claim immunity on his behalf, because as it is established in that specific judgment, there is a difference between criminal responsibility and the immunity, because criminal responsibility is a substantive law, whereas the immunity is going to be the procedural law. We are before this court only to address the immunity attached to Darian Gray as Minister of Foreign Affairs and as a representative. However, this is not a case of criminal responsibility.
You obviously are very familiar with the arrest warrant case issued by the International Court of Justice in 2002. You may recall that in paragraph 61, the court indicated that, and I quote, the immunities enjoyed under international law by an incumbent or former Minister of Foreign Affairs do not represent a bar to criminal prosecution in certain circumstances. Would you be kind enough to recall what are those circumstances specified in that paragraph 61?
Mr. President, in that specific paragraph 61 of the arrest warrant case, it was contended that in cases of the commission of international crimes, that does not mean that the high-ranking official is not going to be surrendered to an international tribunal. However, as we maintain, this is not an issue regarding the criminal responsibility of Minister Darian Gray. Moreover, we are dealing with the immunity breach by the international obligations attached to the state of Ottawa. And in this context, that goes with my last submission, that as consequence of the breach of the international obligations of Ottawa has to cease the detention of Minister Darian Gray, as well as repatriate her to the state of Rasasa. As it is established by the statement of agreed facts, specifically paragraph 52, Minister Darian Gray is still being arrested in a diplomatic guest house. And we can take recourse to the Tehran hostages case brought before this court in the year of 1980, in which the United States argued that as consequence of the taking as hostages of the personal staff members of the United States of America, Iran had the obligation not only to release that hostages and to stop that illegal practice, but also to ensure all the measures and all the possible steps in order to assure the welcome back to that specific staff to the state of the United States of America. And that is why in this case we maintain that Ottawa must cease the detention of the Minister Darian Gray and also repatriate her to Rasasa. Now, it is also important to mention that even though that Ottawa wanted to surrender her to the International Criminal Court, it is also important to mention what is established specifically at paragraph 10 of the preamble of the International Criminal Court, in which it is contained the complementary principle that the court will only have jurisdiction after that the state comply with that specific obligation. In that case, we submit that indeed will be in compliance with bringing back Minister Darian Gray to Rasasa and start the investigation and all the steps in order to necessarily find what is happening, because in accordance with the statement of agreed facts, there is not enough factual evidence that can accuse her as a criminal responsible, and that is why we are asking for the repatriation of Minister Darian Gray to Rasasa. For the all aforementioned reasons, the Republic of Rasasa respectfully requests this court to adjudge and declare, first, that it lacks jurisdiction over this claim, since Ottawa is not a state party to the 1929 Treaty of Ortega. Second, that in this case, the development and deployment of the weaponized autonomous limitation line by the Republic of Rasasa along the border between Ottawa and Rasasa is in compliance with international law. Third, that in this case, Ottawa's contention about the imposition of tariffs of Rasasa falls outside the jurisdiction of this court or is inadmissible, and in the alternative, that the imposition of tariffs on helium hyacinth products is not in breach of the CHC Treaty. As well, that the arrest and detention by Ottawa of Minister Darian Gray constitute an internationally wrongful act, and that as a consequence, she be immediately repatriated to Rasasa. And that is why in this case, we are submitting that it is important to mention that the cornerstone principle of the international law regarding high-ranking officials, such as Minister of Foreign Affairs, is the sovereign equality of the states. And with advancing the claims brought by the agent of the state of Ottawa, they will be against this principle and will be breaching of the equality of the states. May it please the court.
Thank you. Thank you very much indeed. Shall I call counsel for the applicant to provide us with a closing statement?
Mr. President, Your Excellencies, We have two brief points on rebuttal. The first is concerning the care that must be taken when drawing parallelisms between the arrest warrant case and the present case, because the court indeed held that immunities do not represent a bar to prosecution in certain circumstances, and we submit that these are those circumstances, Your Excellencies, because immunities were not designed as carte blanche. They were designed for stabilizing international relations. To the second point of our rebuttal, Your Excellencies, the respondent has rightly stated that a threat under the formulation of the Guyana v. Suriname arbitral award is an implied or express promise to recourse to force. And it is precisely because of this that we should already consider the wall's deployment as a use of force, not a threat, since the power to fulfill that promise is no longer in the hands or under the control of the one that made the threat. Your Excellencies, indeed, technological progress in this regard has merely provided us with more efficient means for going backwards. The agent for respondent initially submitted that in law, nothing is automatic, and thus to that we submit that in weapons, nothing should be automatic either. Thank you.
Thank you. Thank you very much indeed. I call counsel for the respondent to provide us with the closing statement.
Mr. President, Your Excellencies, 2 points in some rebuttal. It was the contention of the applicant that we're not in front of an immunity that is going to bar the arrest and detention in the commission of war crimes. However, in respect of the situation of former President al-Bashir, at this moment, states and the international community never arrest nor detain President al-Bashir for the commission of war crimes because there is a respect of its immunity as a head of an state. In respect of the second ground raised by the applicant, it was established that the deployment of an autonomous weapon system is still a use or a threat of force. However, we might resort to what happened 2 days ago in respect of the Greece and Turkey situation in the border, in which Greece deployed security measures to protect their borders from criminal actions, and there was an acceptance of the European community that the actions were lawful because there were a lawful exercise of the right of an state to protect their borders. And we could resort also to what this court recognized in the Nicaragua case, that even if that there must have to be an express prohibition to a state to possess a certain kind of rules. At this moment, we don't have neither a conventional nor a customary obligation in respect of lack of meaningful human control. And Your Excellencies, the function of this court is not a legislative body. The function of this court is to state the law as it is. And that is what will help us to say that at this moment we don't have a customary obligation in respect of a bar to autonomous weapon systems. What we are here is in the process of a new age, a stage in which states have the capability to protect their people and other states from the killings and the massacres of the war. May it please the court.
Thank you. Thank you very much indeed. The court has taken note of the different arguments submitted to it by the parties. We are very grateful to you for your efforts, and now the court will retire to deliberate. Thank you very much.
Thank you.
¿Nos quedamos o seguimos?
No, vámonos al cuartito. Es logísticamente más fácil que nosotros nos desaparezcamos. Damos una señal. Gracias. Please be seated.
Gracias, buenas tardes, bienvenidos a la Cancillería. En nombre del canciller Marcelo Ebrard quiero agradecerle, señor embajador, muchas gracias por su participación, y a todos los participantes agradecerles y animarles a que sigan preparándose. Como les dije al inicio de esta semana, el derecho internacional es algo vivo. En este caso vimos muchos de los retos que día a día nos enfrentamos en la consultoría jurídica, así es que los animamos a que se sigan preparando. Vamos a dar paso a la entrega de los reconocimientos para después concluir con el anuncio del campeón y subcampeón.
¿Te parece tal vez algunas palabras?
Adelante.
La primera cuestión es que disculpo a mi colega, el doctor Francisco González de Cosío, tenía un compromiso ineludible, pero conjuntamente con la embajadora Celorio tengo el mandato de la Corte de expresar la alta satisfacción de la Corte por las intervenciones que hemos escuchado esta mañana. Quisiera felicitarles y felicitarnos nosotros mismos por el empeño, el conocimiento, la sabiduría y el manejo de la argumentación que han formulado las dos partes. Reitero, resulta un privilegio escuchar a gentes que se han preparado de manera tan intensa y tan detalladamente, con seguridad, durante lapsos muy prolongados, invirtiendo porciones de tiempo muy significativas y al final del día aportando una experiencia única en lo que hace a estos trabajos de la competencia Jessup. Me congratulo y estoy seguro que la embajadora Celorio y ciertamente González de Cosío, lo mismo que el consultor jurídico, nos congratulamos de haber tenido esta experiencia tan grata y les deseo que sigan ustedes en las tareas del derecho internacional público, que resulta tan importante y tan necesario para efectos de la defensa de los intereses nacionales. En la mejor tradición jurídica mexicana, siempre hemos descansado en la argumentación legal con el objetivo de promover y defender una política exterior. Les exhorto a continuar en este camino en beneficio de la nación. Muchas gracias.
Bueno, yo simplemente decirles que a lo largo de mi carrera ya soy embajadora de México, pero sigo aprendiendo. Yo hoy aprendí principalmente del embajador, el presidente de la Corte. Es para mí realmente un motivo de satisfacción, un privilegio haber compartido, embajador, contigo este evento, y aprendí de ustedes también. Así es que hay que seguir aprendiendo y los aliento a que sigan, porque de verdad me llenaron de orgullo. Muchas felicidades.
Entonces, damos paso a los anuncios. El mejor memorial de Respondent es para el equipo 150 de la Universidad Iberoamericana. mejor memorial de Applicant es para el equipo 464 del TEC de Monterrey, Campus Santa Fe. El siguiente reconocimiento es el Spirit of the Jessup, un reconocimiento muy importante porque representa lo que es este concurso, el ánimo, el esfuerzo, la dedicación, y es para el equipo 832, Universidad Autónoma de Yucatán. Es la primera vez que participan. El mejor orador en rondas preliminares, tercer lugar, es para Ana Gutiérrez del equipo del TEC de Monterrey, Campus.
De nueva cuenta, muchas felicidades.
Felicidades, nuevamente. Bien merecido. El segundo lugar en orador en rondas preliminares, Luis Carlos Alonso, equipo 104.
Muchas felicidades.
Felicidades.
Universidad.
De la Universidad. El primer lugar como mejor orador en rondas preliminares, Renata Riverol de la Universidad. El mejor orador en la final nacional de Jessup 2020, Ana Paola Chávez. Aquí quiero aprovechar el gran trabajo de la administración del Jessup 2020, Liliana Oliva, y el excelente equipo de la consultoría, porque gracias a su esfuerzo hemos logrado que 2 equipos vayan a las rondas en Washington y un equipo asista en exhibición, y este equipo tendrá un reconocimiento en aplausos, pero no tenemos placa, no nos lo esperábamos que pudiéramos lograr mandar a alguien en exhibición, y es para el equipo 777 de la Escuela Libre de Derecho.
esta es una vez que ya se
Qué bueno.
Y me complace ahora cederle la palabra al embajador Sepúlveda para el anuncio del campeón y subcampeón.
Yo creo que está aquí. Muchas gracias al consultor jurídico. De conformidad con la deliberación que efectuó la Corte, el subcampeón de las rondas nacionales de México en la competencia Jessup 2020 es el equipo 230 de la Universidad Nacional Autónoma de México. Muchas suerte en Washington. Suerte en Washington, ¿no? Felicidades. Ahora, éxito en Washington también. Mucho éxito. El campeón nacional de la competencia Jessup México 2020 es el equipo 464 del Tecnológico de Monterrey, campo.
A nuestra excelente administradora que nos dirija unas palabras y después los invitaremos a una fotografía y después terminaremos el evento para irnos a celebrar. Liliana.
Muchas gracias. En primer lugar, quiero agradecer el compromiso del consultor jurídico de la Secretaría de Relaciones, el maestro Alejandro Celorio, porque él desde el día 1 me preguntó ¿qué podemos hacer para hacer que Jessup crezca? Así que, entre otras cosas, lo puse a firmar varios centenares de cartas, mismos que afortunadamente arrojaron resultados. Nos dio muchísimo gusto ver a nuevos equipos, nuevas universidades aquí en Jessup, y pues ese es el objetivo, ¿no? Todos los que están por aquí saben la maravillosa experiencia que este concurso significa. Yo tuve el privilegio de participar en su momento. Es un concurso que marcó mi vida a título personal y profesional, y pues siento una enorme responsabilidad por llevarlo cada vez a más estudiantes y a más facultades de Derecho en todo el país. Así que por favor corran la voz. Muchísimas gracias de nuevo a todos los equipos por el maravilloso trabajo que hicieron. Aprendimos muchísimo y disfrutamos muchísimo en toda la semana. Gracias por venir, gracias por participar. Éxito en DC, de verdad estamos muy ilusionados por el maravilloso papel, la representación tan tremenda que vamos a tener por allá. Enhorabuena y muchas gracias a todos de nueva cuenta. Sí, claro. Antes de cerrar, quiero también darle las gracias a nuestros patrocinadores, White & Case México, que de verdad han estado comprometidísimos con la organización desde el día 1, preparativos previos, los jueces, por ahí veo a varios honorable judges. Muchas gracias a Fire and Case también.